I think she could have potentially had a winning argument that regardless of if he ever laid a finger on her, in her opinion, she went through domestic abuse and domestic violence and came out on the other side as a survivor and wanted to speak up for those kind of survivors.
Just a little bit of background. Which area of law do you practice in?
Primarily, I practice wrongful death and serious injury cases. So it's civil, where people get injured or are killed at no fault of their own, whether it's somebody's negligence or an intentional tort done by a company, a trucking company, somebody driving a car, whether it's a negligent security case, an establishment should have done something they didn't do, somebody comes on their property, causes injury or death to somebody. Those are the types of cases that I focus on. The vast majority are civil. My dad is a big criminal defense attorney, was a former prosecutor in federal court. He was the chief criminal prosecutor in the Middle District of Florida in federal court back in the 80s. So when I first started, that's what I did, was mostly criminal work, state and federal. My first 10 trials were criminal. But since then, I've really enjoyed, fighting for victims more, has kind of pulled me in that direction. And now that's almost exclusively what I do. I would say 95% of my work is civil now versus criminal, when it used to be about 50-50.
Okay, yeah. You mentioned Florida. Is that where your firm is based? Sorry.
Yes. So our main office is in Florida. We have lawyers that are barred or have reciprocity in, I think, 25 of the 50 states. And then the way it works in the United States is you can pro hoc vice, or go into different jurisdictions for a specific case. So we've done that. We have cases all over the United States, but our main office and our main hub is in Florida.
Okay, perfect. Switching gears a little bit, I want to talk about your YouTube channel, because you do have a YouTube channel. And I just wanted to know the story behind that. So, yeah, so did you start your YouTube channel just by Amber Heard?
Oh, no. So we started, I wasn't even actually planning on ever talking about real cases that were going on.
Oh, okay.
When we started our YouTube channel, it was COVID had just hit. So there were no more networking or marketing events to meet people. And I was still growing our firm and growing our personal injury practice. Like I said, we were a majority criminal defense. So this was a way for me to still talk to people, engage with people. I was planning on it being more of a local thing to Florida. I've gone on with a couple local news stations, done some spots with them talking about what this means or what that means or why this is happening. And then some people had some questions about cases going on generally. And we talked about a bunch of cases before Johnny Depp and Amber Heard ever came up. And I thought it was a really interesting way to be able to explain the legal process and answer questions with analogies and real life and real world analogies. So people believed it was real, as opposed to me saying, oh, this happened in my case. And people could say, yeah, I could exaggerate. But when cases started getting streamed, which was, again, before Johnny and Amber, It was really easy to show a part of a trial and say, this is really how it is. Like, this is somebody's real life playing out before our eyes. And this is why the court does this, why the judges, why the lawyers, why the bailiffs do this, and what it means and what the reaction should be. And then the jury makes the ultimate decision. So that's just kind of how it spun into doing cases, was a good way to answer people's questions.
Oh, okay. So not just by Amber Heard. Thanks for clearing that up. Because because the way that YouTubers that are lawyers that have been painted in regards to this trial, they've been pretty much called cash grabbers, and ambulance chasers. So I'm glad that a lot of the lawyers that I've spoken to, include, it was just to educate the masses. How many cases have you had that's gone to trial?
So our firm has had hundreds of cases go to trial. Myself, probably closer, somewhere from the 25 to 50 range that I've worked on that have gone to trial.
Oh, okay, so is it a norm that cases usually go to trial, or is it just dependent on what type of case it might be?
So in criminal cases, it's it happens a lot more frequently in criminal cases. In civil cases, it's a lot more unlikely. I would say somewhere around 5% of cases go to trial in civil cases. It's probably double that in criminal cases, but in the grand scheme of things, every 100 cases I handle, 1 or 2 go to trial. That's really what I would say. So it's very unusual, actually, for it to go to trial, especially a case like this. And looking at it from the beginning, I was thinking it was an uphill battle for anybody to win a defamation case, because it is difficult. But every case has a winner, every case has a loser. And so people are going to think, you're against the loser, or you're for the winner, if that's how you see it, or the jury must be for this person, when in reality, it's just how it goes. And a trial is a dispute that two people disagree about. Somebody's got to win, somebody's got to lose, or else it will just go on forever.
Yeah, absolutely. I liked how you summed that up in regards of everything must have a finality. So is that why depositions are usually in place in case like what's the main reason why depositions are actually used in civil context, I would say? Like,
So there's a couple reasons. There's a couple reasons. The first and most important reason is to memorialize somebody's testimony under oath. And that's really important that it's under oath because they know it could potentially come back to bite them if they lose. Once we have that locked in, people are allowed to change their mind or change their stories. But if they do, now they can be impeached or called out for having inconsistent statements, and a jury now can test their credibility. Additionally, depositions are really important as far as fact finding goes. A lot of depositions happen where you ask questions and you find out, oh, this person actually has information that I need. So now I need to go depose them. Oh, they said this person knows something. So now I need to go depose them. So you can find out a lot of information in deposition because they're broad in discovery. They're more narrow when you're going to use them for trial. And that's another purpose for them is if somebody's not available for trial, instead of being like, well, too bad, you can't have them testify for you. Instead, we can videotape it or type it out and memorialize it in some way to get that testimony before a jury if it's important in helping to prove something you need to prove in your case. So there's a lot of uses in depositions throughout the legal process to make sure each side understands what's going on, because that's also a way we can figure out our case sucks, we need to get rid of it, or our client might be lying, or this witness might be lying. When we find out that information in deposition, it's really a fact-finding mission, and that's the reason why we depose so many people in most cases.
When I was reading through the depositions to see what other piece of evidence that didn't make it into the case, I saw this and I was kind of in shock because I didn't really expect to see anything compared to the other depositions that I've, read from this case. This had, those lines on it. So I wanted to get more understanding and, so that whoever is reading it can also understand what they're reading, if that makes sense.
During trial, the page and line numbers are always the most important part. Page number is where that says 43 at the top right. Then you have each line number on the left. So you would say page 43, lines 1 through 3 is what we're referencing. So the judge can see it, the other side can see it, everybody can be on the same page. On the right, because I believe these were videotape, that's probably referencing the videotape timestamp, which again, so if you're going to play it to match it up with that. And the red squares or rectangles and the highlights can be done for a couple reasons. Lawyers can do that if those are parts that they are going to reference, number one. Number two, if you chop certain parts and are going to put them into trial, it's only a fraction of what actually happens in the deposition. There's so many things that come out that end up being irrelevant or inadmissible at trial that you're not going to use. So that's sometimes how they notate on a deposition, this is what we're going to play. And sometimes they will play the video depo and the words at the same time. So you have it notated like this. So whoever's going to push play knows where we're going to start, where we're going to stop, all of the highlighted language each side agrees to. If one side doesn't agree, they get this turned over to them so that they can say, listen, I don't agree with page 44, lines 4 and 5. And that goes in front of a judge as an objection. And the judge makes the call whether or not it's going to stay in the video or come out of the video. If it's going to come out, they'll pull it. They won't highlight it. They'll do just half a page in a square and then the bottom half of the page, leaving out just those two line numbers. So those notations are just for a lawyer or court's reference and sometimes to be played as part of the transcript.
Are judges present for depositions?
No, judges are not. Well, for the vast majority of depositions, no, unless it's highly contested. Somebody doesn't show up, there's a big fight beforehand, and a judge has to be there because both sides are objecting too much, and the only way to do it is to have a judge there. Very unusual, but it can happen. 99.9% of depositions in the United States, there's no judge present. This can go up to a judge, and they can see this if they're following along during a trial, number one. Number two, sometimes if we edit during trial and we have to adapt, we'll just take a good old-fashioned highlighter and highlight it ourselves, give it to each side. If we both agree, sometimes the judge doesn't need to see it. If there's some contention going on, then the judge will also follow along in the highlights because sometimes we don't just present a depo. Sometimes we literally just read the transcript in. I'll pretend to be the lawyer, opposing counsel will pretend to be the witness, and I read the question, she reads the answer, and that's another way to get it in, which again, will have similar notations. These notations are not automatic from a court reporter.
Okay, so you said something that was interesting, which was the highlighted part, you both can agree, okay, cool, this part is going to come in. So let's say someone had objected to hearsay and they referenced it and highlighted it here, but you both come to an agreement. Actually, no, I take it back, it's not really hearsay, I accept it. If the judge was to see this highlight, can they come in and say, actually, no, I'm gonna rule it as hearsay? Can that happen?
Can they? yes, it's unusual for them to do that. Usually judges don't want to make a ton of decisions. So if both sides agree, they'll usually just let them go with that. Even on a hearsay statement, like it would have to be very obvious with no exceptions, because if the two sides agree, there may be some exception that they're agreeing to that the judge doesn't know about. So just because it looks like hearsay doesn't always mean it is if it's not used to be the truth of what is being stated in that statement. And sometimes the lawyers just have a better handle on that than the judge.
Okay, can appellate judges see this deposition as well, or is that
So
just for
appellate
trial
judges can only consider things that happened in the trial.
Okay.
So the only thing outside of the trial, like in this case, that appellate judges can consider is evidence that the judge did not allow in, that Ms. Heard's side proffered or read into the transcript. If it was read into the transcript, regardless as to whether or not that appellate judge thinks it's hearsay, they can consider it if it's part of the record. So if it was presented to them like this, with the box and the highlights, they would consider it as it is, as it came in a trial.
Okay, all right. Thank you so much. Have you ever done family law, like divorces and things like that?
No.
Never. Oh, okay.
I've done domestic violence stuff on both sides, prosecuting it and defending it, but never a family law case, never a divorce case, never a prenup, nothing like that.
In regards to the 2016 deposition, because domestic violence was actually being brought in that deposition, how would that be handled in that setting, juxtaposed to your experience handling domestic violence cases? Did that question make sense, or is it?
In what setting? You said, how would it be handled in that setting?
Okay, that setting would be family law, like because they were going through a divorce. The deposition was in regards to the TRO being permanent. So how would it be handled there?
The TRO hearing is totally separate from the family law case. Domestic violence also, if there is a domestic violence claim or a charge of domestic violence, also separate from the family law case, but they both can become part of the family law case. Every state is really different, so I'm not going to be a lot of help there, but every family law case or every state is different on how they handle divorces. There's no fault divorces, and then there are at fault divorces where you can use that stuff to prove somebody else forced this divorce, therefore I should get more money, or somebody else did something that they agreed not to do in a prenup, therefore I should get more money, or therefore we should throw this prenup out. And it can be used as leverage in a family law case, but they are separate charges. Domestic violence, getting a restraining order, those things are separate from the actual family law case itself.
Okay,
They can be brought in. They can be brought in and be an important part, but you're not necessarily proving to get a restraining order as part of the family law case. That's handled in a separate court.
Okay, do you know much about how it's handled in California? Is that out of your? Okay,
that's not my home ground.
Yeah, that's fine.
It's kind of its own little world over there. California, New York, and even Florida sometimes can be their own world.
Yeah, I understand that. Like, just trying to understand how every state is really looking at this case has been really mind-boggling. Just trying to.
The not so United States sometimes.
Yeah. The irony. In regards to this case and the DVRO hearing, because on the actual application form for the DVRO, he wanted, he had accepted the settlement, but her side did not go through until like the 16th, I believe. So how did that deposition end up happening?
I'm not sure. I don't know the timeline. You mean Amber Heard's deposition?
Yeah, the deposition Amber Heard's deposition from 2016.
I wouldn't think it would happen if everything was signed, sealed, and delivered already. Maybe it was in the process of happening. I'm not sure, but it would be very unusual for a party to be deposed after the settlement had been agreed upon and signed off on.
Now, going into the substance of the deposition, did you notice any inconsistencies, anything that stuck out to you from Amber Heard's depo that was different to what you saw in the trial, or maybe in the same,
Yeah, I mean, I do think that her mannerisms were a little different in the deposition. She was a little more sarcastic, a little less sad, a little less serious than she was at trial. I also think that what was similar at trial and at deposition was she would explain certain events that seem traumatic and should be traumatic, but her explanation and the way she explains them doesn't seem traumatic. So that was always, I think, a difficult thing with her presentation style, is you would expect her to be more somber about certain things that she really wasn't during the deposition. And it's hard. People respond differently to different traumatic events. So it's never like we would want to say, you have to respond like this, or there's no way I can believe you because you responded like that. But the inconsistent way, I think, in which they were explained, the lack of corroborating evidence, especially once you say you have certain things in medical documentation and then it never really comes out that you do, at least that can be presented in front of the jury as relevant information from the case. That's always difficult, which you create burdens sometimes as a lawyer or as a client during a trial or throughout litigation. And if you can't hold up your end of the bargain, then a lot of times juries are going to look at you and say, you said you were going to do this and you didn't really, so we can't rule in your favor. And so I think there was a lot of that, but I think that there were some similarities and some differences in the deposition, none of which I thought were overly helpful to Amber Heard's side or her proving her case. And I really don't think a ton of it was used throughout the trial, because the court did not want this to be a rehashing and a playing of her depo. Her testimony at trial was the vast majority of the evidence the jury heard from her side, not this deposition from the family law case.
There have been a lot of talk that I've seen from other documentaries in regards to how, I'll just say, abusers act on the stand and how victims act on the stand. Away from these two, what are the common mannerisms or behaviors that you see, that is from your experience as trying DV cases? Like, what have you noticed? And I want you to not include Amber Heard and Johnny Depp in this, just
Sure.
your experience. Like, what have you noticed that stood out for an abuser or someone that was adjudged to be an abuser, and for someone that was deemed to be a victim?
Yeah, and I think that I'm not a doctor or mental health professional or anything like that. So coming from the legal side,
Yeah.
usually there's either some kind of documentation that somebody would bring to us, whether it's injuries, medical records, went to an urgent care or a hospital or ER, apology, emails and texts from their significant other, trying to leave, trying to do certain things and not being able to for one reason or another, being kind of swept back into it or pulled back into it multiple times is not unusual. But usually there is some kind of documented evidence to prove, especially if there's long-lasting, significant domestic violence, to prove that injuries did occur and the abuse was long-standing from friends and family members and medical professionals, even if it's just a primary care physician where they notice a bruise here, a bruise there, that corresponds with some of the stories that they tell, what they've been through. So that's just from a legal side, some kind of documentation that helps us prove things, and not just I said he did this, he said I did this, neither of us have any documentation. That's not to say that the abuse did not happen there, but it's very difficult to prove legally speaking.
Let's say that you have a client that claims they were abused, but they don't have anything. How would you defend that client?
So again, I would talk to them and obviously offer them any help that I can. I'd want to connect them with counseling and mental health professionals if they're going through traumatic events like that. If they wanted to file a civil lawsuit, right, in America also and in Florida, private practitioners can't file criminal charges. So if there was a situation where they wanted to sue them for money, I would have to look at it and be honest with them and tell them whether or not I felt like we had enough to prove this case by a preponderance of the evidence. And if we didn't, even if I did believe them, sometimes there's nothing I can do. If they want to file for a restraining order, again, I would go through and see if we had enough. And sometimes that's an even lower bar where your client can come testify. And if the judge believes them, they can grant that a temporary restraining order. And then you might be able to get a permanent one, depending on the he said, she said. But there's not a lot of risk in that money and time wise, as there would be in a civil case, or even trying to get the state attorney's office on board to prove the case beyond a reasonable doubt. You're usually going to need more than just somebody's statement, even if you believe them. It's not to say that we don't believe them, but we would need more than just a statement to take a case like that.
All right. So let's say that you were already deadlocked in a case. So it would be, I don't know, let me not stray away too much from defamation. So let's say you were defending Amber Heard in this situation. We're not like, someone like Amber Heard, let's not use her as an example, but they have already had the case thrown on them. So they are the ones saying, no, this guy is the abuser, but he's turning things around. So basically Darvo. Have you ever had situations like that in your experience?
So I don't do a lot of defense work. We've done a little bit. Almost always I'm on the plaintiff side.
Okay.
If I had a case like this, and it's kind of what I said throughout the trial, and I don't mind using Amber Heard as an example. It doesn't bother me. I don't think they have enough to prove this.
Yeah.
So I would not have necessarily gone on the offensive and again created a burden for myself to prove what he did to me. Instead, I would show how he can't prove that I did this to him. It's just statements. He doesn't have injuries, whatever it may be, whatever they felt like was the strongest part of their case, as opposed to we're both going to play offense and see who can score more points.
Okay.
Under our judicial system, the plaintiff carries the burden, and I would have focused more on that and how this was an opinion and how I felt throughout the relationship, not necessarily that. I think she could have potentially had a winning argument that regardless of if he ever laid a finger on her, in her opinion, she went through domestic abuse and domestic violence and came out on the other side as a survivor and wanted to speak up for those kind of survivors who may not even, have known at the time they were being abused, but after when they look back, they could tell that they were. Whether I agree with that or not, I think that could have potentially been a protected opinion. And there were different ways, I think, to defend this case than to try to prove who the worst person was, which I think is kind of what it turned into.
Okay, so that's actually very interesting because so basically you're saying that she should not have filed the counterclaim at all. That she should just basically concede.
Even if she filed the counterclaim, that's fine. A lot of times defendants will do that as leverage. So then when we settle, we say, okay, and I'll dismiss my counterclaim. So I'm not saying she didn't have to file the counterclaim, but the vast majority of the trial and the time proving the case, I would have spent on that. Because, an opinion is protected here. I can say, you're a bad guy because you wear a sweater over a shirt. That's stupid. It makes no sense, but it's just my opinion and it's protected and I'm allowed to say that. And there's things like that you can make your opinion that are unprovable, that I'm not stating as like a fact that everybody has to agree with, that are protected. And I think if they would have gone more in that kind of gray area, wishy-washy route, as opposed to he is a horrible monster who, abused me and ruined my life, I think it could have been potentially different.
Okay, so I'm glad that you actually clarified that. So even with the counterclaim, actually, because I did see Rottenborn actually try to go down that route by even using Depp's own words and saying, oh, emotional abuse, verbal abuse, all that was way more than the physical abuse.
Correct.
But the jury hearing that, and from what I understand, if she had stuck to just say, look, listen, he was always like this to me, and let's, would it, a lot of people has been saying, and I've listened to quite a few podcasts that, from feminist groups and I call them ideologues. But anyway, the point is they're basically saying that the psychological abuse and the coercive control aspects, etc., was not really being regarded in this case. And I wanted to ask you, do you think that's the case, that it wasn't being regarded? Or was it more of a case that because of the severity of what she was alleging, that it was very hard to pass through? Like, what do you think, like, in regards to that comment?
Yeah, I don't know the answer to that. I would say just from watching it from a legal standpoint, it looked like they focused on that 10% of the time, and then their relationship and the abuse 90%. And I probably would have flipped that and focused 90% on how it was an opinion, on what she was thinking and feeling, regardless of what Johnny Depp was doing. And then 10% on, look, here's a bruise on her nose. Like, he clearly did touch her. He admitted he accidentally headbutted her, but like in her mind, it wasn't an accident. In his mind, it was. He never went to jail. We're not asking for him to be thrown in prison. But there were some physical parts to this relationship that made her feel like she was abused at the end. Something like that probably is if I was asked to defend Amber Heard, probably it would have been something along those lines. Now, whether it would have been successful, who the heck knows? But that I just think was under the legalities of defamation. That is a better argument than I think where they went.
Okay, so just so that I understand, it would have been a more of a focus, like practically her direct exam would have been, hey, this one incident happened in December. and this was where I felt like it was abuse. He says it was headbutt. I'm like, no, it's way more than that. Like, this and that. And just focus on that rather than bringing all of this extra. Is that what you're basically trying to say?
So what I probably would have done on her direct is had her read through the text messages and the emails that were the worst of the worst with Johnny's own words. I would have touched on how he said he had stormed out before. He had kind of grabbed her by the shoulders and accidentally headbutted her and put her on the bed, whatever it was. And if she felt like that was physical abuse, use that instance. And then the texts and the emails to say, this was my life. I felt like I was being abused. He didn't show up, or he showed up drunk to my birthday. Sure, whatever. If you want to throw that in there as, another element of abuse, and then been done. And if Johnny Depp's team wanted to get into, well, what about this that you said that he did? And what about that you said that he did? Well, now they're just kind of bringing up all these other potential abusive moments. And Amber Heard could have said, yeah, you're right. That happened too. Yeah, you're right. That happened too. And then they would have been presenting it and then also fighting with it at the same time, which I think is a lot harder to do than just to defend it and attack it, which is what they were able to do on Cross because of how her direct actually went.
Okay, so I'll just end on this. So do you think it was just the better lawyers just basically won in the end, or was it just like poor planning? Like
a lot of time the client wants to tell their story. And if she believed that was the truth and she wanted to say it, she had her opportunity to tell all the things that she felt were important, and that it could have been as simple as that. You never know what the strategy is behind it, what a lawyer and their client agree on. So it's always difficult, and we just have to that's why really the easy part is just reacting to what comes out in trial. There's a lot of woulda, shoulda, coulda, speculation, whatever. But when we're talking about what a jury had to consider, we all saw what the jury had to consider. And I think based on that, they probably made the right decision based on the evidence that was presented to them in that case. Now, if you try every case 20 different times, they will be 20 very different trials, and you may have some different verdicts, especially in civil cases. But it only happens once for the most part, unless an appeal overturns it. And in this case, it only happened once, and that's the way the evidence came out.
Okay, well, thank you so much. I'm glad that you really sat down with me and gave me a fraction of your time. I really appreciate it. I wish you the best. I hope we can sit down again one day. But yeah, I really do appreciate speaking to you. I love your channel. If you want unbiased opinions, in-depth, thorough coverage, this is your man. Like he knows it's inside out. I'm very underrated in my opinion. But yeah, sorry. What's your channel? Sorry.
No, you're good. It's called The Lawyer You Know. Yeah. And again, it just came out of trying to answer questions for people that don't necessarily know lawyers. A lot of people have lawyers in their life, their uncle, their grandpa, their dad, whatever. So many people don't. So I wanted to just be a resource to try to answer questions and help people understand the process. So that's where we got the name, The Lawyer You Know.
It's very personable. I gotta praise your marketing skills once again. I don't know where you went to business school, but they did a good job.
I appreciate it, man.
No, it's all right. Thank you so much for sitting out with me, and yeah,
absolutely. And good luck to you and everything you're trying to do here. I think it's cool.
Thank you so much. Thank you. Have a good day.
All right.